Ready? 5 seconds. Start. This appeal by special leave arises from the judgment of the division bench of the Andhra Pradesh High Court. The 20 appellants had initiated disciplinary proceedings against the respondent on the imputation that while driving the corporation's vehicle near hospital in Hyderabad city due to lack of anticipation, he had caused an accident in which a person died. Consequently, action was initiated for misconduct and inquiry was ordered for misconduct under the regulation of the Employees Conduct Rule 1963. It would appear that prosecution has been launched by the police for an offence punishable under section 304 IPC and in some cases under section 338 IPC, and they were pending trial. Therefore, the respondents filed writ petition in the High Court for a stay of the departmental proceedings. The learned single judge stayed the proceedings on appeal. The division bench confirmed the same. Thus, these appeals by special leave. It is contended by the learned additional solicitor general appearing for the appellants that the High Court was not right in directing a stay of the departmental inquiry on the ground that it would cause prejudice to the respondents at the trial. In the criminal case, the question is the culpability of rash and negligent driving of the respondent. In the departmental inquiry, the misconduct relates to his failure to anticipate the accident and prevention thereof by his conduct. Therefore, there would be no prejudice in conducting the departmental inquiry. The High Court, therefore, was not right in staying the proceedings. In support thereof, the learned counsel has placed reliance on the judgment of this court. The learned counsel for the respondent, on the other hand, has contended that the ratio in that judgment itself would indicate that only in grave cases the inquiry should be permitted to be completed as expeditiously as possible. Otherwise, the administration would be jeopardized in this case. Such a grave nature case does not arise. The facts in both the criminal case and the disciplinary inquiry constitute the same cause of action or material disclosure of which would gravely prejudice the defense of the respondents in the criminal cases. Therefore, the High Court was right in staying the proceedings. In support thereof, he placed a strong reliance on the judgment of this court. He also placed reliance on the judgment of this court in Food Corporation of India. Therein, the question was that whether the High Court would be justified in quashing the inquiry proceedings after the acquittal of the delinquent officer in the criminal case. The High Court had held in the case that it not expedient to conduct inquiry after acquittal while interfering with that view and holding that the employer is entitled to initiate the disciplinary proceedings. After the acquittal, this court made an observation that the employer fairly had stayed its hands till the conclusion of the criminal case so that it would not be contended that the employer intended to overreach the judicial proceedings. That observations, far from helping the respondents, would go to show that it would be open to the employer to take appropriate disciplinary action based upon the fact situation, whether it could be proceeded with or not would be left to the disciplinary authority and the facts and circumstances obtainable in each case requires to be considered. Stop.